For today's story, we are looking at the upcoming Supreme Court case that might abolish affirmative action first in colleges and perhaps on a broader national scale. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal content, and today will be the day I earn your subscription. For today's coverage, we are covering an upcoming case at the U.S. Supreme Court, and it's a big one. It's students for fair admissions versus Harvard and versus University of North Carolina. This has been a case that was created from square one, manufactured in every possible respect to get to the U.S. Supreme Court, and it has now happened. So this case has been set up by its people to have basically the perfect case, with perfect plans and perfect situation and all the rest of it. And it looks very likely indeed it will overturn affirmative action in the United States. This is a direct challenge to the U.S. Supreme Court case called Fisher versus University of Texas at Austin. But it looks like Fisher will be overruled. So let's take a look at this and see what's happening. The Supreme Court on Monday has agreed to review students for fair admissions versus Harvard and versus University of North Carolina at Chapel Hill. This litigation highlights a number of long-standing flaws in the diversity rationale for racial preferences embraced by previous Supreme Court decisions and adopted by colleges across the country. The Harvard case also features extensive evidence indicating the school's admission system specifically discriminated against Asian American applicants, not just by comparison with other racial minorities, but even in relation to whites. In the Harvard case, the Supreme Court will for the first time consider the increasingly troubled aspect of affirmative action policy. So yeah, one of the key things by the litigators was to look at who's being discriminated against. And Asian Americans are discriminated against. In Harvard specifically, because one of the things Harvard looks at is they do an interview with most of their applicants. And they look at personality and like how good your personality is. And Asians seem to routinely do worse on the personality metrics than other people, found to be boring or not as engaging. So, there seems to be some discrimination there against the Asian Americans who are not being let in proportion to their numbers. So they're being discriminated against, even against whites, namely. So whites somehow get an advantage as compared to Asians, even though Asians are doing better by the objective metrics. If courts stuck closely to the text of the laws they interpret, the case against Harvard would be an easy one for the school to lose. As a private institution, Harvard is not bound by constitutional constraints against racism, unlike UNC, which is a public university. So there are slightly different issues there because you have a 14th Amendment issue that is present for UNC as a public school, but is not present for Harvard as a private school. But the 14th Amendment isn't the only consideration, because there are statutes on point. There's Title VI of the Civil Rights Act, since both schools receive federal funds for student financial aid and other purposes. So even though it's a private school, because it accepts public money, it must be subject to these rules, which prohibits discrimination. Title VI bars discrimination on the ground of race, color, or national origin in any education program receiving federal funds, and it does not exempt well-intentioned racial discrimination in the form of affirmative action. But the Supreme Court wrongly, in this author's view, the author of the article that is, has long interpreted Title VI to allow racial preferences in situations where the court's interpretation of Equal Protection Clause of the 14th Amendment would permit them. And a series of Supreme Court rulings, most notably 2003's Grutter versus Bollinger and 2016's Fisher versus Texas, have upheld that racial preferences in higher education are permissible under the 14th Amendment in some situations in which they're used to promote educational beneficial diversity. That is, ensuring that there's a sufficient number of minority students, sometimes called a critical mass, so other students can be exposed to the diverse, distinct viewpoints. So there's a bit of racism there implied as well. We want to make sure there's enough minorities to have distinct viewpoints, because only minorities or minorities in general have those viewpoints, right? So it's describing viewpoints to particular minorities. We're bringing the minorities in to get those viewpoints. So on the dint of their race, they have those viewpoints. A little bit of racism there, it seems to me. A racially and ethnically diverse student body, the court concluded in these cases, can potentially benefit students of all races by exposing them to new perspectives and preparing them for careers in an increasingly diverse society. Harvard argues, and the lower court rulings in the cases agreed, that race-conscious administration policy is permissible under these policies. Race-conscious, which is discrimination on the basis of race. That's Fisher for you. The Supreme Court standards for acceptable racial preference, or acceptable discrimination, mind you, are far from clear. Grutter and Fisher are frustratingly ambiguous on such key questions as what qualifies as a critical mass of students from a given group that's sufficient to promote diversity, for example, and how much deference courts should give to universities' educational judgments about the type and diversity they need. Why that diversity should be race as such is unclear. Yeah. And also, critical mass sounds like we need a quota, which is illegal, by the way. So there's that. When the court considers the Harvard and UNC cases, it would do well to reject the diversity rationale entirely, or at least subject to much stronger standards of review. I think that the standard is not long for this world, because you're implying that the diversity is in diversity of ideas, but that races have those particular ideas is not clear. Yeah. As it stands, the racial and ethnic categories used by Harvard and many other universities makes little sense. As one expert in an amicus brief supporting the plaintiffs pointed out, the Hispanic or Latino category lumps together such varied groups as Argentinians, Cubans, Mexicans, and immigrants from Spain. Asian Americans include racial and ethnic groups that cover more than half of the world's population, such as Chinese people, Indians, and Filipinos, among others. Such distinct groups as Arab Americans, native-born white Protestants, and recent immigrants from Bulgaria are all classified as white. Asian American combines native-born Black Americans with immigrants from Africa and the Caribbean. Needless to say, these groups have vastly different histories. Lumping them together in a few crudely defined categories makes a mockery of the idea that universities are generally pursuing diversity as opposed to engaging in gross stereotyping. That is the sort of fundamental problem. It's like, we are bringing in together these races because of the ideas they'll present, which is stereotyping. You're assuming that a person who is a certain race will have certain ideas or certain experiences, which seems pretty racist to me. So, there's that. Perhaps even worse, the diversity rationale could be used to justify all kinds of racial and ethnic preferences. For example, to my knowledge, I was the only Russian Jewish immigrant in my class at Yale School. Would this diversity justify Yale using ethnic preferences to make sure there was another in the following year? Such reasoning could even justify racial preferences for white students at historically Black institutions, as was attempted at one such school. Whether you're an originalist, a living constitutionalist, or somewhere in between when it comes to legal philosophy, we should at least be able to agree the Constitution bars this kind of open-ended license for discrimination. For many schools, however, the diversity rationale for racial preferences is likely a smokescreen for the real purpose, compensating minority groups that are victims of long-standing discrimination, particularly Asian Americans. This justification, which has been largely rejected by the Supreme Court, is a much more logically compelling than diversity theory. I have considerable sympathy for it myself, but if universities are to use it, they must at least very carefully calibrate such remedial racial preferences to ensure that those receiving them have been harmed by discrimination. And if compensatory justice is the true goal, Harvard and others institutions' discrimination against Asian American applicants is even more egregious. Asian groups such as Chinese and Japanese Americans were themselves victims of long-standing discrimination by state and federal governments. The notorious detention of Japanese Americans in concentration camps during World War II is just the tip of a much larger iceberg. Yet the Harvard policy not only disfavors Asian applicants relative to some other minorities, but even compared to whites. Data presented at trial in the Students for Fair Association case indicates, controlling for other factors, Asian applicants have a 6% lower chance of being admitted than a comparable white student. So Asians are more white than white, I suppose. The main culprit for the disparity is that Harvard admission officials give Asian applicants much lower personal ratings than students of other races, including whites, even though they on average outperform whites on more objective measures such as grades and test scores. The personal ratings are based on highly subjective factors such as positive personality, likability, and being widely respected. So yeah, this is one of the major problems, as I indicated, that Harvard interviews most, if not all, of its applicants and gives them a personal rating on how personable they are. And so the people doing the ratings, they systemically, in a systemized way, rate the Asians lower than other people. So they do poorly even though they have good academics, which one would imagine is a primary purpose of a university, but whatever. Such anti-Asian discrimination is not limited to Harvard, but also arisen in admission policies elsewhere, including elite public high schools. Sadly, these policies are often pursued by progressives for well-intentioned purposes of promoting equality and diversity, but good intentions alone are not enough to justify them, which totally makes sense. The political right has its own awful record of anti-Asian bigotry. Fair enough, we all have our sins on various levels. But the wrongs of one side of the political spectrum cannot justify those of the other. The Harvard and UNC cases may well set the standard for those other institutions. In its ruling, the Supreme Court should crack down on the dubious diversity rationale for racial preferences and make clear that discrimination against Asian American applicants is just as unacceptable as that of any other group. Thus, that brings us to the end of this discussion of the article of Supreme Court affirmative action cases are challenging Harvard and the University of North Carolina. So yeah, there's a lot of reasons to oppose this, what Harvard and UNC are doing. You can oppose it on first principles. Discrimination on the basis of race is wrong. And as Justice Scalia once famously wrote, the best way to stop discriminating on the basis of race is to stop discriminating on the basis of race. Why do you need anything more? So this is a good opportunity for the Supreme Court to look at this and show these racist reasons. So we want to promote diversity of ideas. You're assuming different races have different ideas, and you're lumping different races into massive groups, which doesn't make sense. So none of what you're doing makes any sense. So I think that the odd-on favorite at this point would be for Fisher to be overruled. I think the Supreme Court will show that, based on the experience of Fisher, it's proven to be unworkable. And I think that affirmative action will probably end as a result of this U.S. Supreme Court's action. They'll have to be careful in how they write it to try to make sure that, places can't get around it. But, that's something for the Supreme Court to struggle with. So it's not something we will for sure follow as we go on. And for the moment, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.